I'm Juliette Wolf-Robin, National Executive Director of American Photographic Artists. APA is a photo association of professional photographers. Our members are photographers who work in commercial, advertising, editorial, corporate photography. Protecting image makers is really important to us. So we have today Stephen Doniger, who's going to talk about how to protect your work online. We actually have a series of different discussions about posting work on social media. So if you go to apanational.org, you can find some upcoming events that are going to talk about how to market yourself on social media, how to grow your following. And today we're going to talk about how to protect yourself. So let me tell you about Stephen Doniger. Stephen Doniger is a partner at Doniger Burroughs, a firm with offices in Los Angeles and New York that focuses on business disputes in general and intellectual property in particular, representing photographers, authors, fine artists, and clients in the marketing, fashion, entertainment, real estate, and hospitality industries. Known for his exceptional record of success in copyright and trademark litigation, Mr. Doniger has earned a spot on the Southern California Super Lawyers, an honor bestowed on only 5% of lawyers in Southern California, and has been selected as the exclusive copyright law expert and recommended attorney for California by global law experts. He serves as counsel for the APA and has been featured speaker and contributing author for a wide range of groups and publications. So we're very happy to have him here today as he works out where he's going to get his presentation up and going. So if you have questions throughout, you can throw them into the Q&A. And I will be monitoring and letting him speak. Hopefully he found the button. Did you get that back?
Yeah, so I think I'm speaking to a bunch of photographers. I think I've committed the cardinal sin of using someone else's equipment and not knowing what I'm doing. So please forgive me in advance if things go a bit askew, but no, we'll have a good talk today. We'll cover some things that you may know, some things that you may not be surprised by, and maybe a few things that, that you do. But, we're here today to talk about social media. And I'm going to see if we have a screen share. Are you viewing? Are you able to see?
Not yet.
You're not. Okay. Oh my God, this is.
It was all working. It was all there. All working.
All right, let's. Okay.
Yay.
All right.
And go back up to the slideshow, yeah? Yay.
All right. All right, so we're here to talk about social media and copyrights. And I'm certainly not. Certainly no surprise to anyone out there that social media has exploded over the last decade. It's estimated that over 2 billion people in the world are currently using social media. And what is social media for? Well, I mean, it's first and foremost for sharing, for keeping in touch, sharing things, sharing ideas, sharing posts, sharing stories, sharing articles, sharing music. Sometimes that's okay, and sometimes it's not. And that's so. There's a few questions that we're going to discuss here today. At the top of the list is, what rights do you have when you post on social media, and what rights do you have to use things that you see on social media? I think that's really kind of the big question. All right. So the first thing to understand with social media and copyrights is really what is infringement? Like what is a copyright? Oops. And we're going to start with just some basics before we get into the specifics of social media. And this is from the Ninth Circuit Model Jury Instruction that establishes what is copyright infringement. And really, to show copyright infringement, all you have to show is that the plaintiff owns a valid copyright and the defendant copied original expression. All right, so you can own a copyright in pretty much any form of artistic work. You can own a copyright in your photographs. You can own a copyright in a screenplay. You can own a copyright in a song. And once you create that work, you own a copyright in it. And if someone uses it without permission, that's infringement. They copy original expression. And copying doesn't just mean making a copy, right? If you look down at the bottom, like it says, from copyright.gov, it explains, as a general matter, copyright infringement occurs when a work is reproduced, that's copied, but also distributed or performed, publicly displayed, or made into a derivative work. If you're in New York and so, there's the new hot play that's out, and you go down to Central Park and you start performing, songs and scenes from Hamilton, that could be a copyright infringement because you're basically reproducing, copying the work. So without, I could just pause right here and you could just think about social media and how we use it. And, do any of us ever take works that would be entitled to copyright protection and, I don't know, distribute them or publicly display them or, make derivative works out of them? Sure. There's an exception to copyright infringement that we're going to discuss in a moment, a few moments, called for fair use. But let's start out by really just going through and looking at the basics of social media. Actually, posting to social media, right? What could go wrong? So the first thing that I want you to realize is that as a general, third parties can't use your social media content without your permission. There's a case back in 2013 that is still good law, where the court recognized that Twitter, in their terms of service, it says, by submitting, posting, or displaying content on or through the service, you grant us a worldwide non-exclusive royalty license with the right to sublicense your content. And so the defendants in that case, who had taken posts off of Twitter and used them, said, look, this gives us a right to use it. And the court rejected that, saying, well, if you read a little bit further, those Twitter terms of service make clear that users still own their content and there's no general blanket license to use the content provided. If this sounds like something you've heard recently, it's because there have been a number of cases involving Instagram and Instagram's terms of service. And my firm is handling, the case that's sort of at the forefront of that, and we'll talk about that in just a moment. But let's talk about it now. And as we go through this, I want you all to understand the reason why we're discussing this is because copyright infringement concerns the unauthorized use of someone's work, the use without permission. And so the very first question is, was there permission? Like, did the user have permission? And there's two different ways that you can get permission to use someone's work. You can get permission by an express agreement, a license, or you can get permission impliedly, implicitly. If I'm hired to do a wedding shoot, and then people post photos from their wedding, it's hard for me to argue that they don't have a license to do that, even if I didn't expressly say you can put these photos on Facebook, because it's sort of implied in the job and in sort of what's standard and customary that they have a right to do that. So that's, and there's not a lot, things to discuss later on. Keeping this on a straight path is a little hard because there's always tangents you can go off on. But let's take a look at Instagram's terms of service, because this has been the subject of a significant amount of litigation in the last couple of years, including a case that we have right now against Newsweek for our client. And we'll take a look at that case in just a moment. Instagram has two different terms of service. There's an API, they have terms of service associated with their API, and they have a general sort of user terms of service. Without getting overly technical, API stands for Application Programming Interface, which is, it's basically just a set of tools that are made available by websites to build software applications to work with those sites. So companies that pull content from Instagram will use Instagram's API to pull that content and are therefore bound by the terms of service when they use that API. It's a slightly different set of rules that a user who has an Instagram page and is posting their own content and maybe sharing some stuff. And in Instagram's API terms of service, it says that users must comply with any requirements or restrictions imposed on usage of Instagram user photos or videos, user content, by their respective owners. And this next sentence, you are solely responsible. So this is telling any media company that wants to go harvest data from Instagram to use in news reporting or marketing or anything else, you're solely responsible for making use of user content in compliance with the owner's requirements or restrictions. Instagram's platform policy, which is the policy that a general user that applies to people just to have and post on their pages, says that no one may, quote, use the Instagram API to simply display user content without our prior permission. And then it says below that, you represent and warrant that you own or have secured all rights necessary to display, distribute, and deliver all content in your app or website. Okay. The reason why this language is important is because Instagram's terms of service have the same general language that we looked at just a moment ago in Twitter's terms of service, that say that when you post on Instagram, you keep your content, you own your copyright. You don't give up your copyright, but you do give Instagram a license to use whatever you post there. And Instagram has a right to sublicense that. Okay. This has become an important issue when posting on social media because some defendants have attempted to argue that when they take things off of Instagram, using Instagram's API, the whole point of that API is to make content on publicly posted Instagram pages available. And therefore they have at least implied, if not expressed, a license to use that content. Courts have thus far rejected that. I mean, there's one court that accepted it and then on reconsideration reversed itself. In our case involving Newsweek, our client, Elliot McGuckin, went out to Death Valley after, remember those heavy rains? We went out to Death Valley.
Stephen, sorry. Let me just
all those heavy rains.
Stephen, your sound is going in and out. I don't know if your phone, you can put it on airplane mode or something just for to cut out other bandwidth pulling from your sound so it doesn't drop out. Sorry about that. Thank you.
I appreciate you letting me know. Hopefully it will make a difference. So, and saw that in the heavy rains, literally lakes had formed in the desert, and took these photographs to his Instagram page. And you can see the embedding here from the Instagram page. And Newsweek said, hey, this is a great story. And they wrote it up. And Newsweek said, well, look, we were using API. We had a right, we believe that we had a license to use this. And the court took a look at the terms of service and took a look in their totality and said, yeah, no. If it turns out that Newsweek, in fact, Newsweek has a license and has a right to sublicense, but that doesn't mean that anyone using API automatically gets the benefit of that right to sublicense. You have to show that Newsweek, in fact, gave you a sublicense if you want to claim that you had a license to use the photo. And the case is still proceeding. So all of that is just to say that you do have rights in what you post on Instagram, and you need to be aware that just because something's on Instagram, even on a public page, doesn't mean that you're free to use it. Okay. So when can someone use content that's been posted to social media? That becomes the question. Does it matter if it's a photograph of you? Does it matter, does it matter if it's a photograph, if you're a restaurant and a celebrity? I mean, let me give you a great, doesn't matter if you give attribution. I mean, let me give you a great example. My wife and I went to Beverly Hills for dinner last year, and sitting across the table from us, at the next table, was Kenny G. And then Lionel Richie comes in, and Lionel Richie goes over to Kenny G, and Kenny G and Lionel Richie are just wrapping it up right in front of us at the table. And we end up taking a picture of them. And like, we posted on Facebook, like, hey, look, Lionel Richie and Kenny G are across, we're at our restaurant. If the restaurant saw that, could the restaurant use that photo to promote itself? Could Lionel Richie or Kenny G post the photo? Could a newspaper post the photo as a newsworthy source that these two were talking in a restaurant? Like what's the scope of use on this? And we could do an entire hour on fair use. I mean, we could do like a day on fair use. It's one of those things that, and I hate to say this as an attorney, but people come to me and they ask whether something is fair use. And the answer is often, it depends. It depends on the context. It depends on a number of factors that I may not always know. And sadly, it's on the jurisdiction you're in. Fair use is, let's take a look here. Let's go. Well, we'll get back to embedding as direct infringement, but so fair use is included in the Copyright Act. And essentially the point is that there's certain use that technically is infringement, technically is a use without permission. But whereas for purposes such as criticism, comment, news reporting, teaching, scholarship, research, it's not deemed to be an infringement of copyright. Now, before we get on to the 4 factors, I want to be really clear on something. Whether something is news reporting or teaching or research, that doesn't end the inquiry. I mean, it used to be, and we represent a lot of photographers, and it's tragic for the industry that newspapers and magazines used to have staff photographers who, hey, there's lakes out in Death Valley, go out there and get some pictures. Why would they ever hire and pay a photographer if they can just find someone's post on social media and take it and use it for the story? So it doesn't end the inquiry. You've got to look at every single case of fair use is a balance of factors. There are 4 primary factors, right? Where you looking at this list here, you'll see right above where it says 1, 2, 3, 4, it says the factors to be considered shall include. Okay, that means this is a non-exclusive list. But you look at the purpose and the character of the use. Is it commercial? Is it nonprofit? Again, not the end of the inquiry, just a factor. You look at the nature of the copyrighted work. You look at the amount and substantiality of the portion used, and you look at the effect and use on the potential market value. And I'll talk briefly about this because it certainly comes up when we take things from social media, when we post things to social media. Like, what are we posting? If I've read, if there's a new Harry Potter book that comes out, and I want to basically let people know, hey, there's a new Harry Potter book comes out. It's amazing. Check out this passage. And I include like a paragraph from the book. That may be okay. If I include an entire chapter or the whole book, I'm now, that's number 3. I'm now using more of the amount and substantiality of the portion used is more than necessary to make my point. And so fair use needs to be considerate, of all of those factors. But of these 4 factors, the most important is generally considered to be 4, the effect of the use on the potential market value. Some of you may be familiar with this case, Andy Warhol Foundation for the Visual Arts versus Goldsmith. This, Lynn Goldsmith is a very well-known, just rock star photographer. She took the image on the left of Prince. The Warhol Foundation, well, Andy Warhol did his Andy Warhol version of the photograph, on the right. Is it infringement? Is it transformative? Is it a different message? Is it, the district court threw the case out, or I should say granted summary judgment for the Warhol Foundation, saying, we think this is transformative. There's new meaning added. It's not the same thing. The case recently went up on appeal and the decision is still pending. But I listened to the oral argument and the questions asked by the appellate judges during the appeal hearing. And there was a tremendous amount of focus. And it's really interesting. I suggest listening to it if you're interested. There's a tremendous amount of focus on one particular fact. After Prince died, there was a magazine that wanted to put an image of Prince on the cover. And they were considering Lynn Goldsmith's picture on the left. And instead, they went with the Andy Warhol version on the right. So when you look at that fourth factor that we were discussing just a moment ago, the effect on the potential market value of the copyrighted work, the court was very concerned with the fact that even though this is a different version, Mrs. Goldsmith, in fact, lost out on an opportunity to license her work for the cover of a magazine to a derivative work of her own photograph. And they said, that's a problem. So how do we protect ourselves? Oh, there's one more, we can pass over the other issue, I think, in the interests of time. But so the question then becomes, how do you protect yourself? And there's a number of things that we're going to go through that I want to discuss. And one of them is watermarking and providing copyright notification. People, whether it's true or not, the number of times that I've heard infringers from people who use works without permission say, I didn't know it was protected by copyright. I didn't know it belonged. I didn't use it. One of the ways that you can potentially avoid infringement is to watermark, to put your name, a copyright notification. That's going to help tremendously. In the event that you, in the event that you can't prevent infringement, and the truth is you often can't prevent infringement, what there is to do is police the market. Okay? You have to. There are a number of services out there. You can open up an account. If you're the copyright owner, especially with photographs, it's a little bit easier. If you're the copyright owner, there's services like, whether it's Pixie or Image Rights, or there's a number of them. And there's a thing, you can just yourself do a search with TinEye and to find infringements. And the reason why that can be so important is that copyright infringement has a 3-year statute of limitations. That statute runs from the last violation. Now, this has been a problem with posts on websites because the web is, it's unfathomably large. It's impossible to know everything on the website at any given time. And you certainly can't trust that you're going to come across an infringement or that someone's going to point it out to you if you're not actively searching for it. Anyone who wants to get compensation for the use of their work on social media or otherwise needs to be doing some searching and find things, because there's this potential 3-year statute. Now, I do want to make sure that everyone is aware that most circuits follow the discovery rule. The discovery rule says that the statute of limitations won't prohibit the recovery of damages, even from more than 3 years ago, if the plaintiff was unaware of the infringement and knowledge was reasonable circumstances. Okay. In the Ninth Circuit and previously in the Second Circuit, even after more than 3 years, you can seek damages. Now, I want to emphasize something though. It's 3 years from the last infringing act. If someone posts something online in 2016, and they haven't touched that post since then. The vast, vast majority of courts consider that to have been the last infringing act. There's been no further infringing act since then, and so your statute would run. Under the discovery rule, you may still have a claim for damages. Now, I say may because the Supreme Court, a couple of years back, in Petrella versus MGM, said that any infringement, and forget about it, you're welcome to read what's up on the screen, but essentially the argument in this was the Raging Bull case, and essentially the argument was, are you barred by laches, by an equitable doctrine separate from the statute of limitations if you've known about the claim for more than 3 years, right? The discovery rule is, well, what happens if you find out about, as long as you find out about the claim within the last 3 years, you're good. Petrella said, well, what happens if you knew about the claim for more than 3 years and you move forward? And the court said, well, no, you can still pursue the claim, but you're limited to a 3-year look-back period on damages, because that's what the statute says is a 3-year look-back period. Petrella states a successful plaintiff can gain retrospective relief only 3 years back from the time of suit. Now, that seems inconsistent with the discovery rule, but Petrella recognized that most circuits follow the discovery rule and left the discovery rule in place. What does that mean? Well, after Petrella, the Second Circuit, which is in New York, the Second Circuit considered this very question and said, the only way we can square the discovery rule with Petrella is to say that even if the claim is more than 3 years old, if you discovered it within 3 years, still bring a lawsuit. You can still seek injunctive relief. You can stop someone from using the image. But per Petrella, your damages are limited to going back 3 years. Now, Leonard versus United States is a really interesting case, and one that most courts have not followed, and most courts have actually rejected. But the interesting thing about Leonard does microscopic photography. In the interest of full disclosure, he's a client of ours. He took the photograph you see here of a stem cell in 1996, and NASA posted it to their website in 2004, right? NASA last updated that page in 2007. Leonard didn't file suit until 2018. And the government said, wait a minute, we got statute of limitations issue here, Petrella. The court said, look, every time, the Copyright Act includes the right, as we mentioned in the beginning of this talk, to display the work publicly. And display means to show a copy of it, either directly or by means of a film, slide, television image, or any other device or process. So given those statutory definitions, the court concluded that each time a user viewed NASA's webpage, the copyright work was displayed on that user's computer at the direction of NASA, and that each display is a separately accruing act, so that there have been infringements within the last 3 years. Most courts have not followed this, but this is an argument that's out there regarding the statute of limitations, and it's an argument that obviously applies to social media, because social media posts keep getting viewed and shared, and if each one of those constitutes a separate act of infringement, then okay. The other thing that you need to do to protect yourself is registration. A copyright infringement suit, you can't bring suit on a copyright claim unless there's registration, unless you're a foreign copyright holder, which is to say the copyright was first published overseas. I know with the APA, we've done whole presentations on the importance of registration, but what I really want to make clear is that registration, in a nutshell, registration makes available statutory damages and attorney's fees that make it worthwhile to pursue and police the market for infringement claims. In fact, those damages can be up to $30,000 for innocent infringement, up to $150,000 for willful infringement, and you can also get costs and attorney's fees. But here's the thing, all's not lost if you haven't registered. as long as you've taken some other appropriate steps, including putting on a watermark or some other information to manage your copyright, to let people know that it's your work. Or you can seek statutory damages. So this was another Leonard case, Leonard versus STEMTech. Leonard, he had an expert who testified that there's a benchmark reasonable licensing fee for similar uses that would be between $1,200 and $2,500, but the court was able to consider a multiplier given the rarity and exclusivity of these stem cell images. So even without actual damages, even without timely registration, you may have a case where your licensing fees are significant. I've had the pleasure of representing some amazing photographers. I think everyone is familiar with Annie Leibovitz. We represented her in a case involving a number of images. Most of all, if not all of them, were not registered, but we could actually show a licensing history for her works of, that was significant enough that it commanded a pretty high settlement value in the case. The other thing you're going to look at is like, what's the use? You may have posted something on social media, or you may be using something on social media, right? But is that use just, for your own personal benefit, or is a company using it on social media to sell products or, seeming endorsements? Over the past few years, and I don't, many of you may have heard about this, but about some of these cases. But over the past couple of years, there have been a tremendous number of notable athletes and celebrities who've been sued for using people's photographs on their Instagram pages or on their Facebook pages, or, and a lot of those, the allegation is you're using this to promote your new brand. There's, Amy Schumer was sued for posting photos of herself and her son on her Instagram account to allegedly push her clothing line. Jennifer Lopez and her production company were sued for posting a paparazzi photo of herself, to promote her brand. LeBron James. There've been a tremendous number of people.
Are you saying that the situation would be different if they were just posting saying this was a really fun photo taken by so and so, is different than if in fact they're promoting a brand with it? Or are they always promoting a brand because they're a celebrity?
No, there certainly is a difference. And there's both, the difference is part practical and part legal. If you're going to look at fair use, remember that one of the factors in a fair use analysis is the commercial or non-commercial nature of the use. So the more commercial the use is, the less likely it is that something could be deemed a fair use. The other side of it is really, again, whether you have timely registration or not, the amount of damages that you can expect to get is going to depend on the nature of the use. There's a licensing value that works have when they're being used as part of an advertising campaign or promotional campaign that's very different from the licensing value that something would have if someone simply wants to post an image on their account as like a photo they like. So that's what I'm saying. Okay. Earlier we talked about watermarks. Even if you haven't timely registered your image, if someone takes a photograph or another work and removes copyright management information, removes a watermark, removes a gutter credit, removes something that would indicate you as the copyright owner, there is an entirely separate and discrete section of the Copyright Act that addresses that as a separate violation. And even without timely registration, permits statutory damages of up to $25,000 plus costs and attorney's fees. So, be wary when you find something on social media. Be wary of cropping it and cropping out, any identifying information of the owner, and correspondingly, you can use that to your benefit. As mentioned earlier on, that CMI can prevent infringement in the first place. But if it doesn't, and someone's then bold enough to then even remove it, it can significantly increase the value of pursuing that claim to the copyright owner. All right.
So most photographers don't post, when they post their images, they don't put a watermark on there. Do you suggest that people do put a watermark, has their name specifically on there, because it would be worth more if somebody took that off before they used it?
Absolutely. Absolutely. And there's three reasons why I recommend that. One of them, maybe two of them, we've already discussed. It's for avoiding infringement, for potentially increasing the value of these cases when they come to me so I can get them more money. But the third thing, just from a business perspective, when you're a photographer, your name is often your brand. You want people to know who you are. And the more people see photographs that they like that have your name on it, the more your name sticks out and the more likely you are to get work. And it's just as a marketing thing, I think it's a brilliant idea. But the number of times that people say, I didn't know this, I couldn't use this, I didn't know who it belonged to, I didn't know how to try to get permission, I didn't realize that this wasn't okay. You put a little copyright notification on it, it just kind of like puts a ping in people's head that like, oh, maybe it's not okay to use this. So. And
somebody's asking, is metadata in the image the same as copyright watermark on our image?
So it certainly can be. From a perspective of removing copyright management information, it absolutely can be. It doesn't give you those same benefits of avoiding infringement in the first place because people aren't going to necessarily see that or look for it. And it doesn't give you necessarily the same like marketing and PR benefits for your self as a photographer in your business. But for purposes of CMI removal and the damages available under Section 1203, absolutely.
And then somebody asked, so we know you own the copyright the minute that you take a photo, but you need additional protection. You need to register the copyright. So why is that required? Why does the Copyright Office or the Library of Congress require that you register copyright in order to get the additional rights?
So there's two reasons for that. The first is that the Library of Congress, it's a library. It's literally attempting to be a library that has all creative works created in this country. That's their goal. And so in order to enforce rights in something, it's just sort of the deal. It's like, you need to deposit this with the library so that we add to our collection of all the creative works made in this country. And then you get these additional protections and a right to go to the courts. And it's just the deal that the courts have made, or sorry, that our government has made with us.
Go ahead.
Go ahead.
Okay. So, and then Facebook, we know strips out the metadata. Is the metadata stripped out of Instagram as well?
I'm sorry, you cut out one more time.
The metadata, when you post to social media like Facebook, it's stripped out. The metadata is stripped out. Is that the same on Instagram and Twitter and the other platforms?
Many of them do end up stripping out the metadata for ease of transferring. And just to be clear, a claim under 17 USC 1203 there's a discussion right now about Congress amending it because it's often too hard to prove. It's not a strict liability where you've removed this data and therefore you're liable. You have to show that someone stripped out the data, generally speaking, with the intention of concealing or facilitating the infringement or an infringement. So there's a few other steps that need to be proven, but which is why these claims don't generally apply to Facebook or Instagram. But a watermark is a whole different thing, which is why that's a preferred approach.
And does a watermark does it need to be their company name, their photo business name, or could it just be the name of the photographer? Like, so if they're an LLC, do they have to also include those letters next to their name?
No, what's optimal is having the copyright note, like the little C, and then like the name of whoever would be is either the copyright owner or the person who would be you'd reach out to. As long as the information is sufficient to identify the owner, slight imperfections like leaving off LLC or something are going to be of no consequence.
Okay.
Yeah. So when is it time to contact an attorney, and how do you approach infringers? We're going to speak briefly about the DMCA. DMCA, for those of you that don't speak nonsense lawyer, is the Digital Copyright. It's an act that was put in place to address what would have otherwise been an inevitability. Because of the strict liability nature of copyright infringement, if platforms that allow third parties to post content were liable every time those third parties posted content, they would be sued out of existence. If we're talking about social media like Facebook and Instagram and Snapchat, if every time an unauthorized use of someone else's work were put on Facebook or Instagram or pretty much name the site, they literally would be sued out of existence and social media wouldn't exist anymore. So what our fine government did is it passed a law that says that provided the company, the platform registers for social media protection, registers for protection and establishes an agent for serving notifications on, they get a limited safe harbor. So Instagram or Amazon selling the third-party products, let's stick with social media. Facebook has a website where someone is posting, pirated versions of someone's song and all kinds of songs and photographs they don't own. As long as Facebook designates a DMCA agent to receive notifications of infringement, and then it acts responsibly and to promptly, and what promptly means is still subject to some debate and gets argued in courts, but acts with reasonable promptness to take down infringing content on their site, they have immunity from infringement for things posted on their site. So when we talk about, and this was one of the things that Juliet, that I saw that you listed in the topics for today, is like the best way to contact an infringer. If the infringer is a site that allows third parties to post content, and that site didn't directly post the content, but it really was just posted by a third party, there's a required way to contact, you don't really have options. Like, you need to send a DMCA compliant takedown notice that provides certain information, and that's it. If the site doesn't then promptly remove the work, doesn't address the infringement, then they could become liable. My firm had a lawsuit last year against Amazon where they're selling a lot of infringing product. Our client had sent takedown notices on just literally like dozens of different products, and Amazon wasn't promptly taking them down. And we said, this is BS. And it's crazy. You get into it and you really realize like the sheer volume of claims that these companies have to process. And it's hard to feel bad for them, but I feel a little bad for them. But it is what it is. If the infringer is not a company that's entitled to DMCA protection, or if they haven't registered for DMCA protection, or there's authority that says that even if you're a service provider and you register for DMCA protection, you only get that protection for infringements that occur after you registered. So let's say that last year, Facebook registers for DMCA protection and they just hadn't done it before, and you find an infringement that predates that, they could in theory be liable. But assuming that you're not, that you don't have that limited liability and you don't have DMCA safe harbor protection, there's no one way to give notice. But the one thing that I'll say is always put it in writing. You might want to take a look at the websites. Sometimes companies on their websites have a specific email address to send copyright infringement claims to. But if you do that, as opposed to sending an email where you're going to have a copy of that email in your sent inbox, if you do that, always make sure that you have a copy of what you sent them. You want to keep clear records of when you sent these notices, these takedown notices, what the response was, etc. Because the number of times that I've had people come to me and say 6 months later, they're getting the runaround and their work is still up. Well, that's now evidence of willful infringement, right? Like infringement, if you use something and you don't know that it's copyrighted, or it's like, maybe you should know. There's always an argument that whether someone acted recklessly, because people should know that photographs and other works are entitled to copyright protection. And so the use of them, to me, is like default. But once you've been told by the copyright owner that you're using their work without permission and you don't promptly immediately take it down, like now that's a knowing, ongoing unauthorized use, and that firmly falls into the bucket of willfulness in my view. So always keep documentation of that. Whether you reach out to companies yourself or have an attorney do it really depends on your level of comfort and sophistication. We certainly have clients that feel comfortable reaching out directly and saying, hey, you're using my work without permission, and pay me a licensing fee. And then they come to us if they can't work it out. We have other clients that are just like, look, I don't want to deal with their legal people or their business people. I'm just here, deal with this. And sometimes we resolve claims on letters and correspondence for our clients, and sometimes we proceed to litigation. And in terms of like, when is it time to contact an attorney? Be sure that it's a claim that you're willing to put in the time to handle. Like, realize that there's no, it's not like going to Vegas and you pull the slot machine and maybe some money comes out and maybe it doesn't. If you file a lawsuit, you need to be ready to answer questions in the discovery process, provide documents, potentially sit for discovery. A lot of cases get resolved before that happens, but if you're not willing to potentially go there, like that's just something to keep in mind. But beyond that, I certainly recommend that people establish a relationship with an attorney. Firms like ours handle. We've brought in over $10 million for artists over the past couple decades, and did I say 10 million? 100 million? That wouldn't be very impressive.
What's the average, like a normal case that somebody's bringing to you is, what's the value usually? Like if they see something and they think, okay, this is probably only worth a few $1,000s, is it worth going to an attorney? Should they figure it out on their own? Is it only the high value cases you go to an attorney for?
No, not necessarily. We handle cases of significantly varying values. We have clients of ours that we've gotten multiple six-figure settlements for, and then we also handle smaller cases for those clients. And it's like that's kind of our thing. It's like we want to make sure our clients are taken care of, and we'll handle like the big with the small. If you're just coming to us with a case that's like a non-registered image and that's all you got, like we may not take it, but anytime you've got something that may be a viable claim, you want to establish a relationship with an attorney, know that attorney, with an attorney who's willing to take the big and the small together. Some of you who've heard me speak before have heard the story, but we had a client that had a small claim, and we filed a lawsuit on their behalf. And the defense counsel, I know, Juliet, I know you've heard the story. Defense counsel reached out to us and said, look, let's just get this thing resolved. And I said, all right, let's get it resolved. Like we got all the information. We made a demand of $4,500. The guy said, you're crazy. I'll give you $1,700. I said, you know what? I gave you the no haggle price, $4,500. He said, I can get you $3,000. I said, $4,500. We took that case all the way through litigation, all the way through trial. Because we had timely registration, the jury still found non-willful infringement, but gave us the statutory maximum of $30,000. And when the judge found out that they could have settled the case for $4,500, and really like forced us to go to trial with no real defense. He awarded us all of our costs and attorney's fees, and it turned into a 6-figure judgment, and they actually paid it off. And we were able to go to our client and say, here's your, $30,000 the jury awarded you. We took the cost and fees, and like that's having a timely registration lets you do that. And it's the intention. I mean, the intention of the office, Copyright Office. Well, it's really not the office, it's really the legislature in passing the Copyright Act. The intention of them in making those things available is to encourage people to prosecute infringement claims. There's this view that we're richer as a society when more people are making more art and literature and poetry and photography, and you want to encourage that. And so the way you encourage that is by making sure people are out there doing it, by making sure that when those people's work is used without their permission, they're compensated, and that the people that are using it without permission are appropriately deterred.
And you're pursuing that in the United States, or do you also pursue it for foreign infringements?
Right, so everything we've been looking at today is under the United States Copyright Act. The United States Copyright Act generally doesn't apply extraterritorially. It doesn't apply outside of the US. Which actually, I'm glad you asked that question, because it reminds me of something that I forgot to mention earlier. When we look at these DMCA takedown notices, there's a procedure where, and you can see the very last point is sometimes it's a good way of getting domestic jurisdiction and venue. You could be suing a company that's a foreign company that you would never have jurisdiction over. But by virtue of using these platforms, any user of the platform agrees to jurisdiction here in the US under certain circumstances. So for example, we had a client who's based in Australia, and someone accused him, and we think wrongly, it was like predatory, they were just trying to take down a competing page, accused him of having a page on YouTube that had infringing content. And it was all public domain Looney Tunes cartoons that our client had the most hits on, was the top. Someone else basically just took him dead, took down a competitor. Our client filed a counter notification saying, no, this isn't infringing. And under YouTube's terms of service, if you file a counter notification, you consent to jurisdiction in the United States. And then he was then open to having a lawsuit filed against him. So for any of APA's members, any photographers who post a takedown notice, if the other party may be overseas and maybe outside of jurisdiction, but by sending that DMCA takedown notice, if they file a counter notification and say, no, we have a right to use this, they've now made themselves subject to jurisdiction in the US, and it's a good way so it's really helpful for US based photographers and other artists to enforce their rights. Okay, I see we're coming up in the last 5 minutes or so, or I'm happy to answer any other questions. I know we covered a lot of ground.
So there was a question about the metadata again. If you can, when filling out the metadata, is it okay to just put your website on if you didn't want to put your email or your phone number or other personal information? Could you just put your website address in the metadata?
Yeah, absolutely. The key point of this, though, is that if we're looking specifically at a copyright management information claim, it has to be clear that it's copyright management information. So that's putting the little C is the easiest way to do that. But if you just have like a name, like that's, you want to make sure that it's not ambiguous or unclear whether you're just referring to what the photo is of, or like a title or something. You just want to be clear what that is.
And would you ever want to just send somebody an invoice if you saw that they had posted your work? Would you want to send them an invoice, or would you want to go about it a different way?
So it depends. It depends on a couple things. First, well, let me give you my general answer before my it depends answer. My general answer is no. And the reason why I say no generally is because you don't know the scope of the work. We've had cases where a client sees their work, they're flying on an open up the Sky magazine on the airplane, and they see their photo in there. I was like, oh my God, like is that photo being used just in that magazine, or is it part of some bigger ad campaign? Like what's the, how do you know what amount would be the appropriate to invoice for without knowing the full scope of use? And you don't know it based just on what you find. But even if you did know what the full scope of use was, even if it was just, even if you were sure it was just, they're just using one particular place, if you have timely registration, if you have a CMI claim, if you have something where you can seek statutory damages are not limited to your actual licensing fee. And we've had a lot of claims where there's this thing in negotiation called anchoring, where you put a number out there and it sort of anchors things in. And so then sometimes people...
Sorry, Steve. I'm going to have you stop screen sharing because it might be what's also cutting out your mic. It might be taking some of the bandwidth there. Okay. We'll see if that's better.
Got it.
Trying to get you
yeah, no, but I think I was just saying that that you don't want to. Apparently I need more bandwidth. I didn't realize. An attorney it may make it harder to get a better amount if you send the invoice early, as opposed to negotiating, your fees. The other thing is that in any other case moving forward, someone's going to ask for any and all invoices you've ever sent to try to establish the value of your work, and that may or may not be the number you want to put out there.
And somebody's asking, when does federal copyright and the right of publicity conflict?
That is a whole nother program.
We'll do a different one on that. There was also a question about published, unpublished. We did a talk on that. You can find it on our YouTube channel. You can find some of the comments on apanational.org where we went over that. We'll be doing more of those because that question is the $100,000 question for everybody. What is published, unpublished?
Now, I will say generally they don't. Generally, you have to get permission from both the photographer and the model, the person in the image, in order to use that work. Commercially, they are two distinct rights. There are limited instances where they may overlap, but we're not going to get into that on this call. Okay.
How is a DMC notice sent to an infringing website with a private registration on who is?
So in order to be eligible for DMCA protection, a company has to register for DMCA protection. And part of that registration is they have to designate an agent to receive those notifications. If you just do a Google search and type DMCA agent search, you'll find it'll bring you to the Copyright Office Copyright Office page, where you can type in the name of the company or the web page and look and see whether they're registered for protection. And if they are, it'll tell you who to direct that takedown notice to.
Okay. Any last questions? I know some of these are a little bit more complicated than we can answer right now. Okay. All right. Well, I want to thank Stephen for being here today. We will be doing more in this series. So if you want to send to me, executive director at apanational.com, emails about what you'd like us to talk about more in the future, what specifics. We're going to try to drill down into specific areas on different calls. And we're going to get Stephen better bandwidth. So thank you for being here. Thank you for those who attend.
I'll make sure to get some more bandwidth.
Okay, and we'll be posting this.
Thank you so much.
All right.
Thank you so much. It's been a pleasure.
Thanks.